and thank you for joining us. My name is Leslie Hatfield. I'm with Integrated Financial Group here in Atlanta. I'm joined today with my partner, Kevin Garrett, and we just have a wonderful webinar planned for you today. We're just, as part of our Education Empowerment Series, we're bringing audience some conversation with some of the smartest, most successful people in their field. Kevin is a nationally recognized independent fee-based financial advisor who specializes in the unique needs and challenges that women, particularly those going through a divorce or death or change of job or career, face in today's financial world. Prior to joining Integrated Financial Group, Kevin was a partner and a COO and the head of a financial planning department at another Atlanta-based firm. He also worked for Morgan Stanley Wealth Management Service as a financial advisor. Hi, Kevin.
Hey, Les, how are you doing today?
I'm doing all right. Excited to be here?
I'm very excited to be here.
Great. Well, we have two of the greatest guests today, Rich Marr and his business partner, Barbara Patilli of Inflection Point Law. Rich and Barbara will be speaking about the legal considerations for entrepreneurs before starting a business. I'm very excited to hear what you all have to say. Just a little bit about Rich. He's a corporate attorney who founded Inflection Point Law almost 2 years ago. Prior to founding Inflection Point Law, Rich worked in the corporate department of a large full-service law firm in Orange County, California. Rich has worked on well over 100 M&A transactions, representing both buyers and sellers and assisting clients with forming over 50 new businesses. He advises clients regarding legal issues in all stages of the growth cycle, including formation, capital funding, employee compensation, commercial contracts, and exit planning and execution. In addition to his legal experience, Rich worked 10 years as management and information technology consultant with Anderson Consulting and Ernst & Young prior to becoming an attorney. Hi, Rich.
Good afternoon, Leslie.
Great to have you here. Just a few words about Barbara as well before we get started. Barbara's a corporate attorney who joined Inflection Point Law last year. Prior to joining the firm, Barbara served as general counsel and VP of business affairs to an international software company where she advises boards of directors and executive management on corporate governance, capital funding, corporate policy, and strategic customer relationships. Barbara advises Inflection Point Law clients on a broad array of business transactions with a focus on entity formation, executive employee compensation, and commercial and government contracts. Barbara holds a BAA in International Business from George Washington University and an MBA in JD from Georgia State University, where she interned with U.S. Securities and Exchange Commission and the U.S. Equal Employment Opportunity Commission. That's a lot. Hey, Barbara.
Hi, thanks for having us.
Glad to have you here. We are really excited to hear what you have to say today, both of you. But if we could just, before we totally get started here, I just want to do a little housekeeping. If everybody can find the chat box over on should be on the right side of your screen, and make sure that everyone can see that, because we're going to be throwing up a few links as we go, and I want to make sure that everyone knows where that is and knows how to use it. If you could just type in a little hey or something, that would be great. And we're hoping everyone will stay to the end of this webinar. I promise we won't go more than maybe 20 minutes tops. But if you do, we're going to be giving a free gift away at the end from Kevin and Integrated Financial Group. So I think we are about ready here. And we can begin with you, Kevin. I think that you've got the beginning questions here.
I do. I do. Yes, I wanted to start off asking Barbara and Rich a little bit about the different types of legal considerations that need to be taken into account. I know I have a lot of clients that when they get ready for their quote unquote retirement, they're not necessarily ready just to go play golf the rest of their life. They're in many cases looking for an opportunity to start a business, whether it's part-time or full-time. And they have a lot of questions that we need a professional to help answer as it relates to what types of things to to consider. And so that's why we're so excited about having Rich here today. So Rich and Barb, just to start, maybe you could tell us a little bit about maybe some of the legal considerations that an entrepreneur who's interested in starting a business need to take into account.
Sure, I'll take a stab at that. That's a really broad question, so I'll paint with some broad strokes. And certainly the legal issues are going to vary based on the type of business. So I'll talk about some of the key issues that are common to virtually all the types of businesses we work with. So first, let's just start with the basics. You're ready to form a business, you need to consider the entity type, because if you don't consider the entity type, you could have significant personal liability, and you could also have adverse tax consequences. So I'll get into a bit more detail in a few minutes about the different entity types and the selection process, but that's critical. Next, if you're not forming alone, but with a partner or partners, it's really important to get an agreement amongst yourself in writing. The devil's in the details here, and thinking about all the things that could go wrong. Some of the key things to include in your agreement amongst the co-founders are the ownership percentages. Even though you might have, say, 3 owners, doesn't mean necessarily you're going to be 1/3 each. It could be based on what each of you is contributing. You definitely need to outline the roles and responsibilities for everyone involved, the time commitment for everyone involved, compensation for all the co-founders. And then, of course, you need to get into mechanics. How's the business going to be managed? So who's going to be able to make the decisions, and what are you going to do if you have a deadlock? Most common ownership structures is 2 partners working together. Of course, it's possible for the 2 partners to have different opinions on how the business should be run. So you have to think about what happens if there's a deadlock. Are you able to get out of the partnership? And exactly what are the mechanics for that? Are there ways to resolve that deadlock? You got to obviously specify what money everyone's going to put in. So what are the capital contributions? And then going back to that roles and responsibilities that I mentioned earlier, you got to consider what happens when someone's not performing. You laid out the roles and responsibilities. One of the co-founders not doing their job. What rights do you have against them? Do they forfeit their equity? Do you get to buy it at a low price? You buy it at fair market value, or maybe you don't necessarily have remedies, but you need to think about that and not get in a position where you find out your partner's not doing what you expected and you're not able to move forward. So those first 2 I would highlight. Barbara, I'm sure you have a lot of thoughts.
Sure.
What do you think are some of the other key considerations?
Well, aside from the entity type and the deal terms, one of the other things a new business should consider is protecting their intellectual property rights. Now, we're not IP attorneys, but we do want to highlight some of the common issues. So if the value of your company is linked to intellectual property you have created or will create, then it is essential that you take the steps at the beginning to protect those assets. So for example, your business name and your logo sounds simple, but is that name and logo even available to use? So I would suggest that you look at the United States Patent and Trademark Office. They have this trademark electronic search system, which basically allows you to type in the name of your business and see if it's already claimed as a word mark by somebody else. Also, the Secretary of State for each state, you can confirm the name availability and make sure that that name is not taken by somebody else already. So it's important to understand where are you going to do business. So you might want to do that search at multiple states depending on where your business is going to be located and where you're going to be doing business. The second area for intellectual property rights you want to consider is whether or not to register your IP. And what steps do you need to take to protect your rights and prevent others from using your IP. So again, for example, your patents or trademarks, you're going to need to register with that U.S. Patent and Trademark Office. But your copyrights, and that would be things like your manuals or your computer programs, that could be registered with the U.S. Copyright Office. A third area of intellectual property that you want to consider and how to protect is your trade secrets or your proprietary information. That could be customer lists and things of that nature. Usually this is done by two ways, and it's contractually done through a non-disclosure agreement with third parties or people outside, maybe your customers or your vendors or your independent contractors. And then the other is with your contractual way is through with your employees, where you would have your employees sign some sort of proprietary information and inventions assignment agreement, so that anything they perform actually is owned by the company, your company. Aside from intellectual property rights and protecting those, the other types of things that we see is employee issues. So again, we're not employment attorneys, but I want to highlight some of the common things that we see that, you know, we can at least identify and perhaps help you with. But the first is your worker classification. You know, there's three ways that you could classify a worker: either an exempt employee, a non-exempt employee, or an independent contractor. So your exempt employees, you do not have to pay overtime. They're typically salaried positions for executive or professional employees, computer professionals or outside sales employees, versus your non-exempt employees. Those are typically hourly positions. And they are entitled to overtime pay under the Fair Labor Standards Act. Counter that with your independent contractor. Now, to be an independent contractor, you need to evaluate the worker and what they're doing. So does that worker have the right to direct or control how the work is done? Is there any kind of training provided regarding the company's required procedures and methods? Is there a continuing relationship, or is this a short-term duration assignment? Is the worker doing full-time work where they don't have any other clients that they, you know, are working on? Are they working on the employer's premises, and are they furnishing their own tools or materials? Those things factor into whether or not the classification would be an independent contractor. Other employee issues relate to wage and hour compliance. So for example, that varies state to state. So that's how many hours constitutes full-time work under that state requirements. Are there requirements to have a break schedule, 15 minutes every 4 hours? Are there other timekeeping requirements of, you know, can you punch in or out before or after the allocated time that the employee's required to start work or leave work? So those are things that you want to be looking at. Also, employment matters you want to consider are what are the key agreements, meaning that, you know, we talked about the proprietary information and inventions assignments. That's pretty standard for employees that are coming in to sign that. There should also be some sort of policy that prohibits the employee from taking IP from any prior employer. So the last thing you want to do is hire an employee from your competitor, and that employee uses proprietary information of your competitor to help you, because that just exposes you to unnecessary risk of a lawsuit. So again, you'd want some sort of policy in place preventing your employees from doing that. So generally speaking, you do want an employee handbook to ensure legal compliance, communicate the policies, introduce the employees to your company, your culture, your values. So those are some other areas. Rich, do you want to speak further to key areas?
Just a few other things I'd like to mention. Of course, pretty much everyone now has a website. If you just have an informational website, there's really nothing you need to do legally. But if you have a website with more functionality, such as ordering functionality, anything where your customers or other third parties are going to be inputting information, you need to have terms of use. And in doing so, I highly recommend, if you can, you require click-through to make it enforceable, so that things like your disclaimers that you include and dispute resolution procedures will be enforceable, and other terms that you include. And you also need a privacy policy and how you use the information that you receive on your website, And what's critical with the privacy policy that a lot of companies overlook is it's more important to adhere to your policy than to have a great policy. That where companies get in trouble is not adhering to their own policy, because there aren't that many requirements, at least in the U.S., for privacy policies. And then if you're working internationally, you'll certainly need to consider safe harbors that are available for the European Union. So that's when things get a bit more complicated, and you'll want a lawyer involved. Other things to think about is you definitely want to have a good form contract if you're going to be if you're in a business where you're entering into contracts with your customers or suppliers on a regular basis, so that you can impose your standard terms rather than accepting theirs. And there you want to you want to be developing your own form, not grabbing one off the internet or from a past job, because you don't know how that was drafted, and there might be some innocuous seeming terms in there that are working against you. And then the final thing that I'll mention is if you're raising outside money, you got to make sure you comply with securities laws. And two things I want to raise that come up a lot are having unlicensed broker dealers, as well as bringing in non-accredited investors. So as far as broker dealers, a broker dealer is someone who assists you in raising money. Very common to engage someone who maybe used to be an investment banker or just has a lot of connections, and they are going to connect you with potential capital sources. And if all they're doing is connecting you with people, providing introductions, that's fine. You're not going to run any problems with the broker-dealer rules. But if they're doing more than that, if they're negotiating the deal, then they have to be a licensed broker-dealer, or all the money you raise, the investors will have rescission rights. So it's a death blow to the company. And it's something that it might sound like, oh, who would ever do that? I see it every month. Clients, send me a contract where they're engaging someone who's a non-licensed broker-dealer, and they're compensating them based on a deal. Then as far as non-accredited investors, you're doing a private offering, so just not an IPO where you're registering with the SEC, so you're providing more limited disclosures. I highly recommend you stick to only accredited investors. And I'm not going to get in depth to what an accredited investor is, but basically it's someone with a lot of wealth and sophistication. There's very detailed requirements, as you can imagine, that are contained in the SEC rules. But if you sell to non-accredited investors, your disclosure requirements go up dramatically, which is going to be a lot more time-consuming, a lot more expensive, and expose you to a lot more risk. So those are a few other things that that come up a lot in almost every business that I deal with.
I bet you guys see so much stuff. You just said every single month people come to you needing legal help to kind of unwind from some of this. Can you give us some examples based on business types of some of the legal considerations out there?
Sure. Let's go through 4 different business types.
Okay.
Simple one. Let's go through a single retail location. So that's your store and your strip mall. Let's go through a more substantial business, a manufacturing business, a company, XYZ Corp is producing widgets. And then let's go through some with maybe a bit more intellectual property. So a software company, and then an individual service provider, or an independent consultant. So maybe someone who used to work at that software company, then going out on their own. So starting with a single retail location, there aren't going to be a lot of complex legal requirements. The items that we went through before, the one that'll be most important for a single retail location is the employment issues that Barbara went over, and in particular the wage and hour compliance. That's where I see companies like this run into the most problems. So you definitely want to make sure you engage a labor attorney up front. Nobody wants to spend a lot of money on attorneys when they're starting a business. I guarantee you that'll be a relatively small investment up front. If you don't make that investment up front, you'll end up with a lot of problems down the road, whether it be in litigation or fines and penalties from your local labor authorities. So moving on to a manufacturing business, obviously they're a little bit more complex legal situation. 2 things that I would highlight there would be your standard supplier agreement or purchase order terms and conditions, depending on how you operate, and then your warranty. So on the purchase order terms and conditions or your supply agreement, the key thing is to have your own form. I talked earlier about having a form customer agreement so that you get to impose your forms rather than accepting either default terms or the terms of your customer. If you're selling goods, for example, if you don't define the terms in your purchase order, then you're subject to the default terms under the UCC, which might not be ideal for you. So develop your own form so that you can allocate risk the way you want to, determine how customers accept your product, determine their payment terms, limit the warranties that you're providing, limit the liability you're subject to. It's worthwhile to have your own form. Then on your warranty, a few things to be aware of if you're providing a warranty is one, you have to take into account both state and federal warranty laws that could have, fines and penalties if you're not adhering to them, or make the warranty that you're providing illegal so that it's unenforceable. But you also need to be, in the case of warranties, aware of implied warranties and magic words. I'm not going to get into the details of both of those, but I will tell you that by just including any express warranty, you're subject to all the implied warranties. So what can seem like, oh, I'm just providing this little warranty here, actually can have a much greater meaning. So warranty is a place where I see a lot of my clients make huge mistakes unwittingly. And then lastly, just from a practical perspective, I always urge my clients to be as narrow in drafting their warranty as possible. Typically, especially new businesses, want to provide a great warranty and do everything to make things right for their customer. And that's a great policy, but not necessarily a great warranty. It's generally better to have a more narrow warranty so that you're not as legally obligated, and then you can have a broad policy where you'll make everything right for the customer. So those are really the key issues I'd see for a manufacturing business. So Barbara, you want to talk more on the intellectual property side on with a software company or a service provider?
Sure. So as Rich teed it up, the other two companies relate more to intellectual property. Specifically, if you have a company that's creating intellectual property rights, such as software development, and your IP is a central thing of what you're selling to your customer, then you're going to need to make sure that you have agreements in place with your employees such that the work that the employee is doing constitutes work for hire, meaning that the owner of the work product is the employer itself. Again, anything that the employee does should be assigned to the employer. This goes back to what I was saying before as the inventions and assignment agreement. The other is if you have an independent contractor. So you have a special project that you are outsourcing to some specialized developers, either an individual or a group of individuals or another company. And again, you want to make sure that what they're producing on your behalf and you're paying for, actually you own it. So again, you want to make sure that there's provisions in that agreement with the independent contractor that says it's a work for hire and assigning all those rights to you. So at the end of the day, when the product is done, you own it. You're not licensing it. You're actually the owner of it. You could create derivative works from it and things of that nature. You can modify it with or without. So a year later, you want to modify it, but you don't want to use that same independent contractor. You don't want to have to keep going back to that independent contractor. So your agreements with the independent contractor and the employees are critical for you to maintain the ownership, particularly if IP is central to your business. On the flip side, as Rich was suggesting, that maybe you worked for one of those companies that developed the IP, and now you broke off, you started your own company, you're a service provider, you are the independent consultant. And in those cases, you want to look at your form of agreement, your engagement agreement with your customer, which is now the software development company. You want to make sure that any intellectual property, your background IP, stays owned by you, not your customer who is now the software development company. You want to perhaps fight back and say, no, I'm going to keep this. I'm giving you a price break, so I'm going to keep the ownership of anything I produce, even though you're paying for it. I'll give you a license. So your engagement agreement talks about who owns, who has the rights, who has the license to create derivative works, things of that nature, and that becomes a very critical document. And again, as being an independent consultant or an independent contractor, you have to make sure you're properly classified as an independent contractor, as we discussed earlier, under employment issues.
Guys, one of the questions that I get a lot from my clients is the discussion around what is the right type of entity that they need to basically incorporate as. Can you help kind of clarify that for us?
Sure. I alluded to this earlier as being one of the critical decisions that you make right at the beginning of forming your business. So I want to talk through 4 common entity types. First of all, the sole proprietorship, which is just someone going into business under a trade name, and then a general partnership, which is just 2 or more people going into business under a trade name, and then LLCs and corporations. So I think to understand why you would select a particular entity type, it's important to first understand the basics about those 4 different types of entities. Is everyone else just seeing Kevin instead of me right now?
No, I see you all.
No, I see all of you.
Okay, Kevin's on my main screen, but I'll just proceed. So for a sole proprietorship, basic attributes of a sole proprietorship is that it's an unregistered entity, so you don't make any filing with your Secretary of State in the applicable jurisdiction. And you have to have some sort of doing business as or DBA registration or trade name registration that's usually done locally at the county level. That's where I'm opening my sandwich shop and I say, I'm going to do business under the name Rich's Sandwich Shop. So you have to make that filing, but that's different from being a registered entity with the Secretary of State. As far as tax-wise, how a sole proprietorship is treated, all income and expenses are reported as personal income of the sole proprietor. So it's very simple. From a tax perspective, the sole proprietorship doesn't exist. The downside to a sole proprietorship is you have personal liability, which is unlimited for anything that happens in the business. So I'm operating my sandwich shop, somebody slips and falls, sues me for $5 million, I'm uninsured, I'm on the hook personally for that entire $5 million. I don't have any entity to shield me from that. And I'll talk about shielding entities in a moment. So next, moving on to a general partnership, very similar to a sole proprietorship. The main difference is that it's more than one person. What many people don't realize about a general partnership is that you can unwittingly enter into a general partnership. You don't have to enter into an agreement with a partner. If 2 or more people just start working on a business for profit together, they formed a partnership, whether they intended to or not. So that's something to be aware of if you're starting to work on something with someone and but you're not confident that they're the right person. Realize that you could unintentionally be entering into a partnership with them. A partnership can be either registered or unregistered. If it's a straight general partnership, it wouldn't be registered, but there are other variations on that, like limited liability partnerships that can be registered and can limit liability. I'm not going to get into those in the scope of our discussion today, though. General partnership, like a sole proprietorship, is a pass-through taxation entity. So income and expenses are reported as personal income by the partners, of course, ratably based on how they own the partnership. And as I mentioned before, you may or may not have a partnership agreement. Obviously, as I recommended earlier, I would highly recommend having a written agreement. And like a sole proprietorship, a general partnership has unlimited personal liability unless you form one of those other types, like a limited liability partnership. Okay, so now I want to shift gears to the registered entities where you can have limited liability, and these are the most frequently used entities that I see. So I want to start with LLCs, or limited liability companies, which in general is the entity that I recommend for entrepreneurs starting businesses because of the great flexibilities that LLCs have. And that's really why they were created, was to help entrepreneurs and provide a lot of flexibility. So these entities are registered with the Secretary of State, and they provide, just like you might be familiar with a corporation, they provide a corporate veil of limited liability. However, they have fewer formalities that you need to maintain in order to maintain that limited liability shield. Because unlike with a corporation that I'll get into in a moment, you're primarily governed by the agreement of the members of the LLC rather than by a corporation's code. So there are a lot fewer requirements imposed on an LLC, which, as I mentioned earlier, makes it really flexible. So an LLC can be managed either directly by the members, or you can appoint managers, which, if you want to call them something other than managers, like a board of directors or board of managers, you can do whatever you want, because again, you're flexible in how you set up your operating agreement to define the management mechanics. There are no limitations in LLCs on the types or number of owners, so both individuals, corporations, trusts, any type of person or entity can own an LLC without having any tax consequences. Okay, so switching gears to a corporation. Again, it's a registered entity. Again, it provides limited liability, but now there's a lot more structure. It has to be managed by a board of directors, and rather than primarily being governed by agreement, it's primarily governed by statutes. You have to comply with the corporation's code that in the jurisdictions where you form the entity, and tax treatment for a corporation. You can select either S corporation tax treatment, or if you don't make that election, you'll be treated as a C corporation. With S corporation tax treatment, you have a pass-through, so it's somewhat similar to a partnership in that income and expenses are passed through to the owner, so there's only one level of taxation. While with a C corporation, you will pay taxes on income for the corporation at the corporate rate, and then when you make a distribution out to shareholders, you'll have to pay the applicable income tax rate for the individual shareholders. I think I actually didn't talk about taxation of an LLC, so let me circle around and hit that now. So an LLC, you can elect any of three tax treatments. You can elect to be taxed as a C corporation, as an S corporation, or the most common election is to be treated as a partnership. So that's another nice thing about the LLC, is the flexibility from a tax perspective, and the ability, again, like with an S corporation, to be able to get the pass-through tax treatment. But I pointed out on the LLC, you're not restricted on the ownership of the LLC in terms of having company, corporations, or other entity types own an LLC. There are restrictions on ownership for an S corporation. You can only have so many owners, and they have to be natural persons. They can't be entities. So that's a downside to an S corporation, because for entrepreneurs, you almost always would want an S corporation versus a C corporation. Failing to make that S election is one of the tragic mistakes I see entrepreneurs make, and it can have really, really negative tax consequences, particularly when you're looking to sell. So after hearing a little bit about these, you might be thinking, well, why would anyone select a corporation as an entity type anymore? There actually are some valid reasons, but they aren't generally applicable for most entrepreneurs. And even if they are, that's usually something down the road, and it's pretty easy to convert from an LLC to a corporation. That's why I generally recommend an LLC. But some of the reasons would be, one, you wanted to issue stock options. LLCs with partnership tax treatment can't have stock options. There's some things that are similar, but you can't have stock options. That's limited to only a corporation, and that can be done with either an S or C corporation. International investors will generally require C corporation due to tax implications, and that detailed analysis on that is beyond the scope of what we're going into today. If you're planning to go public, it likely makes sense to be a corporation, and probably even a Delaware corporation. And I'm not going to get into the differences or reasons why you would incorporate or organize in one state versus the other today. And then there are certain other types of institutional investors that will just require a corporation, even if you're not going public, just other institutional investors. Then the last thing I want to highlight about these the corporations and LLCs which have limited liability is when you do have personal liability, because it's not an absolute shield. I don't want you to have a false sense of security that if I form an LLC or corporation, I don't have to worry about any personal liability. There certainly still are situations. One would be if you ignore your entity form. If you can mingle your assets with the assets of the company, treat the company piggy bank as your own, then you're going to lose the benefit of the limited liability shield. For corporations, if you don't follow corporate formalities like having shareholder meetings and meetings of the board of directors and maintaining your minute book, you'll lose the benefit of corporate shield. Again, this is an advantage of an LLC. You have fewer formalities. If you breach fiduciary duties, and this used to apply only to corporations, but in many jurisdictions now, LLCs have implemented fiduciary duties. So that's a situation for personal liability. And then if you do other things yourself, like if you provide a personal guarantee, which is frequently required by landlords on leases, if you personally engage in tortious conduct, those are bases for personal liability. Or if you receive improper distributions, and that just means the company really doesn't have the money to pay a distribution, and it pays distributions anyway, thus the creditors aren't able to collect money that should be in the corporation. That's a basis for recovering against you personally. But those are a much more limited set of circumstances than under unlimited personal liability that you have under sole proprietorships and general partnerships.
Wow, I can't believe our time is already 37 minutes into this. I could have like a half-day seminar with you guys. There's so much to learn, and I know this is like the tip of the iceberg. Barbara, Rich, thank you so much for this little bit of time but all of your knowledge. Do you have any final words for those budding entrepreneurs out there? You have any other just little suggestions in the few minutes that we have left?
I sure do, and they're really not from a legal perspective, because a lot of the mistakes people try to rely on lawyers to fix really are not fixable by crafting the best agreements or selecting the right entity. So first of all, I would say, know when to consult experts, whether it's a lawyer or an accountant, somebody that handles employee benefits. Know when you're getting out of the area of expertise that you can handle. And I liken this to when you're at home and you're doing a do-it-yourself project. There's some things that you can do a great job on. Like for me, I'm a gardener. I can go out and plant plants great in the yard, and I can make my yard look better than, frankly, if I engage the service. But when I'm going to put in hardscape, I know I need to call a professional. That's beyond my capabilities. If I do it on my own, it's not going to look good. It's going to bring the value of my home down. When you do that, when you do the same thing in your business, while I think it's a very good idea and really a must for entrepreneurs to learn the basics about all the areas where they get help from service providers, I certainly encourage my clients to learn as much about the law that they can, so that they call me only when they really need my expertise, not for the most basic legal questions. I try to educate them and provide them with resources over time. So know when you need help. Next, hire a good accountant. I know I'm this is again tying to service providers, but I'm not just saying hire an accountant. Pretty much everybody does, because you're forced to, because everybody has to file tax returns. But it's critical to hire a good accountant, because they can provide a lot of business advice to you. And critically, they also, a good accountant can connect you with good service providers, and you're going to need a portfolio of good service providers to help you along in your business. So starting with a good accountant that may cost a little bit more than the cheapest accountant is going to be worthwhile. And then the last thing that I would highlight is your business plan. Of course, have a business plan, but have a business plan that you can really manage to. Don't have something you throw on the shelf. It could be a perfect looking plan that's 100-page long and you really thought through it, but if that's what happens, it just sits on a shelf, it does you no good. If it's a one-page business plan that you can manage to, use that, but always be working that plan versus having something that was only done at the front end of the business. So Barbara, I'm sure you have a few thoughts. What other recommendations do you have?
To tie onto your business plan, the other thing that you need to be paying attention to, and the accountant, I guess, is expect to need more money than you had originally anticipated, and make sure you minimize your expenses. The running a business is all about cash flow, so make sure that you plan and manage that cash flow so that when you do the work in January and February 1st you send out an invoice, then expect the money hopefully 30 days later if that's what your contract says. So all of running a business is about managing your expenses and your cash flow. The second word of advice would be only do business with people you trust and that you've vetted, because life's too short to do business with people who don't have a reputable way of doing business, or they make you feel slimy, so to speak. Your gut says, I don't think this is the right fit. Listen to yourself. Listen to your gut. There are plenty of honest customers out there with good integrity. Do business with them. You'll enjoy your business much more. And then the third word of advice would be network. Business is to some extent a numbers game. The more people you engage with, the more opportunities you have for somebody to refer a customer to you. And people want to help you succeed. But you have to go out and reach out and meet people. So that's a bit of socializing and it's out of some people's comfort zones. But keep doing it. The longer you do it, the more you follow up, the better the end results will be. So that's pretty much my thoughts on last words.
Yeah, I really want to reinforce that vetted and trustworthy business partners, because I'm frequently asked to craft provisions in a contract to protect against someone that a client doesn't think is trustworthy. There's really nothing you can do in a contract. If somebody is not going to operate the right way, I mean, yeah, you could have a contractual right to recovery, but then you're getting into litigation and everybody loses in litigation. You want to avoid that whenever possible. Litigation should be reserved for the unanticipated problems. It shouldn't be you enter into a contract with a plan of litigating because you know the person's a slime ball. That's an expensive way to operate your business.
Yeah, you can have a good contract, but if it's not a good person signing it, you can't do good business with bad people, right? So trust your gut. I love that, Barbara. That's so true. And people, your head overpowers your gut a lot of times, but that gut really is smarter sometimes than your brain, in my opinion, anyway. Great points. Kevin, do you have any other questions? I know, as promised, if everyone stayed to the end, I want to make sure that everyone has your ways to reach each of you. So I'm going to post that in the chat box, and you can just click on that link and save it. It will go up to a page that will have contact information for both Rich Marr and Barbara Patilli, as well as Kevin Garrett, Integrated Financial Group. And also the little free gift that we're going to have, I will have a link to that if you bear with me. I'll stick it over here in the chat box.
Les, one thing I will say that I think the time we're spending with Barbara and with Rich today just reinforces why we believe that really everyone, you can't be an expert in everything. And from our standpoint, where our experience and expertise is more in retirement planning for our clients and investment strategies, it does not follow into the scope of the things that Rich and that Barbara do. So it's really helpful for me as well as for our clients to kind of know where to go to and to use the resources that we have available to us in this great market that we're in to talk to real professionals who can go very deep into a particular subject matter. And I just really want to say once again, I appreciate both Barbara and Richard's time today. And we look forward to hopefully having you guys back on down the road and go a little bit deeper into some of the subjects that you touched on today.
Thanks for having us.
Yeah, like I said, I'd like to have a half day with you guys and just pick your brains, and so much valuable information. Thank you so much for your time.
It's our pleasure.
Have a great
day. Thanks to everyone for listening.
Yeah, and we'll be posting the recording of this too, because there was so much information. In the next couple of weeks, we'll have a posting ready, and that way you can go through and maybe fast forward to certain parts that you want to make sure that you take special notes on. So anybody watching will get a recorded view of this as well.
Great.
All right, thanks, Leslie. Thanks, Kevin.
Thanks, Leslie.
Thanks, everybody.
Have a great afternoon.
Bye.
Bye-bye.